to be summoned to shed light on the issues before the select committee.
Thank you, Senior Counsel. We will give our ruling on some things, and you will hear that. CS and his team.
Thank you very much, Honorable Chair and members. We will comment on 4 issues by way of preliminary matters. The first issue is the whole question of witnesses and witness statements. The second will be the question of the competence of the motion before you. The third will be the request we have made on adjusting some of the timelines. And of course, the last will be the issue mentioned by my learned senior, the question of summons to some persons. I want to begin with the question of the whole witness statements and the calling of witnesses. Honorable Chair, it is our application that you decline any request on the part of the mover to call as a witness any person whose either affidavit or sworn statement was not part of the motion before you. The reason we say that is 2 matters of principle. Number 1, you are here to investigate the motion as approved by the House. This committee has no power to interrogate any other material that was not before the House. The second reason of principle, Honorable Chair, is a question of fair trial. When this motion was approved and served upon the Honorable Cabinet Secretary, he was required to respond to the motion as placed before the House, as approved by the House. And now we are being told of endeavors to introduce additional material that he has not had the opportunity to read, to review, and to respond to. This matter, Honorable Chair, is not just a procedural issue. It is a question of fundamental justice that is governed by a whole regime of 5 different sets of laws. The first one being our Constitution, the second being the Fair Administrative Action Act, the third being the prevailing case law on this specific matter we are placing before you, the fourth being your standing orders, and the fifth being the rules of this committee itself. And it is our submission, as I hopefully show you shortly. Whichever of these regimes of law, and I've mentioned them in their hierarchy, whichever of them you look at, there is zero room for introducing extraneous material that was not part of the documents that were before the House when it appointed this committee. We'll begin with the Constitution, Honorable Chair and members. Article 50 of our Constitution has a right called fair trial. This right, Honorable Chair, includes, among other things, the right to confront and to respond, and more importantly, when you read Article 50, subparagraph 2J, the right to have the information and the allegations and the evidence against you in advance. Those are not my words. It is the words of our Constitution. The evidence must be submitted in advance so that, as a matter of fair trial, the person accused will have the opportunity to respond to all the allegations against him. This matter of fair trial is so important, Honorable Chair. It is one of the 3 rights in our Constitution that are absolute, which means they cannot be limited. This can be confirmed from Article 25 of our Constitution. It lists certain fundamental rights which cannot be limited. Not even Parliament can enact a law to limit those rights, and one of them is the right to a fair trial. This right is old, Honorable Chair, given the type of legal system we have, It is as old as the year 1215, more than 800 years ago, when we had a document called the Magna Carta. Article 47 of our Constitution again talks about the right to a fair administrative action. I only mention this, Honorable Chair, because the communication from the Speaker to this committee said a number of things. One of them, of course, was that these proceedings are quasi-judicial, but for purposes of my submission, the Speaker also said in his communication to the House that the proceedings before you are governed by the Fair Administrative Action Act, which is the one that governs this whole question of fair procedure and whatnot. That brings me to the prevailing case law on this matter, Honorable Chair. Luckily, we are not bringing to you a matter that is new. This matter has preoccupied our country to a level that we had to appoint a 5-judge bench of the High Court sometime in 2015, when the Republic of Kenya at that time, beset with terrorist attacks, wanted to change the law on inquiries and criminal proceedings so as to tinker with this right to fair trial, so that the state could go to a court of law and introduce the evidence right at the eve of the trial, right at the very 11th hour. And we have a decision, I believe, petition number 628 of the year 2014. I said it's a 5-judge bench decision. And the issue in that case, which luckily my senior, Dr. Kamino, was actually the one arguing this point, and the court was happy to agree with him, that it is not permissible, even when the country is faced with existential threats like terrorism. You cannot do what the move of the motion now is attempting to do, which is to bring a motion to the House, have the motion approved by the House, sent to the committee, and then...
Madam Chair.
Yes, Honorable.
May I just inquire if we have this ruling before us? Is it in the bundle? Which bundle? Please point to us where it is.
The Honorable Chair have endeavored to print the relevant parts of that ruling. We didn't have it, of course, in advance because we had not noticed until last night, very late, that this issue would arise, because we were working on the assumption. I've just given to the Secretariat. It's a fairly long ruling, so I only bothered to print out the relevant parts, and I think it is highlighted in the document. It is at paragraph 346. And all we are saying, Honorable Chair, it is not every day problems like this, our Chief Justice appoints a bench of 5 judges. Usually the practice is 3 judges, but this was a matter that was so critical to the administration of justice in this country that the CJ had to constitute a bigger bench than usual of 5 judges. And the matter was settled. It is not a question of discretion. It is not a matter of us trying to balance this or that. It is there in black and white from the High Court, which is the court charged with interpreting our Bill of Rights. And all we are saying is that it is not permissible. And the reason it is not permissible, Honorable Chair, I told you this matter is as old as 800 years. Back then, there used to be controversial methods of inquiry in which evidence was withheld until the last minute. People used to be tried before an institution called Star Chamber using very unorthodox means. In short, trials 800 years ago used to happen, for lack of a better word, if I may say, where the accuser would keep surprising you, like a conjurer pulling out rabbits from his trench coat. And because this matter was so critical, Honorable Chair, it was the subject of revolutions in England, no less than 3 revolutions. In one of them, the monarch actually lost his head, and all we are trying to do is to tell you, it is not possible. It does not even arise for consideration. Lastly, Chair, You have your standing orders. Standing Order 64 says that by the time the motion comes to the Speaker for approval, it should already be accompanied by the witness statements, by sworn statements, and all other items of evidence. Those are not my words. The thinking must be that by the time you make an allegation as serious as the ones before you, you had better have done your homework, you had better have done all your preparation, and you had better put forward all the material upfront so that the accused person will have then the opportunity to respond. And of course, your rules themselves, which is Rule 2, if I'm not mistaken, I am being guided by Boniface that I might be mistaken, but you've already adopted the rule again. Rule 7, consistent with your standing orders, which says that, if I may read, in presenting evidence, the sponsor of the motion shall not introduce any new evidence that was not part of the allegations against the Cabinet Secretary. And very lastly,
try to conclude.
Yes, to conclude, Honorable Chair, there is a further practical difficulty we have with these so-called witness statements. As I told you, we were only told this last evening. The Cabinet Secretary is unable, as we speak, to confirm whether, one, the so-called witnesses are persons who actually registered for the fertilizer program at the inquiry, whether, as a matter of fact, they obtained fertilizer, and from which depot, and on what date. So we are completely unable, even if we so wished, given the timelines we are working on, to respond to whatever those witnesses may purport to say. And the very last point, Honorable Chair, you must be told what was the difficulty in putting up these witness statements, in getting these guys to swear their witness statements according to Standing Order 64 at the time the motion was brought before the House. I have not heard them attempt to tell you either these people were nowhere to be found, we tried to trace them, we couldn't, one of them was in hospital, something like that. No reason has been advanced why there was non-compliance with Standing Order number 64. On the contrary, what you have is a mover that assumes, like I kept saying last night, they have a right as a matter of course to keep pulling these surprises. And for those reasons, Honorable Chair, we urge you to reject that request for additional witnesses. We will deal with the question of the defective affidavit, given that I've already run out of my time. When we respond to the case, I will still beseech you to give directions on the other requests we had made, which are in writing anyway, and on the questions of summons. The parties cannot be the ones requesting you to summon anyone. It has to be the select committee exercising its own independent mind to decide we need to hear from so and so. It cannot be me, it cannot be my learned friend telling you, or insisting or pushing you, summon so and so. Because a person summoned is not a witness of the Cabinet Secretary and is not a witness of the move of the motion. They are just someone summoned by the committee to enable it to understand something. Thank you.
Thank you. Honorable.
I'll kindly ask my lawyer to make just a brief statement about that.
Okay, may I praise you, my lady. My lady, the issue before the Honorable members of the Select Committee is a national issue of considerable gravity. And the objections that are being raised, with tremendous respect to my land friend, they do trivialize what has been placed before you. And I urge you very respectfully, the members of the committee, that my land friend will have to be controlled. Otherwise, we may not be able to dispose of the matter before you within the timelines that have been given at all. If I may very respectfully refer you to the Constitution, which my learned friend is relying on, and which he has been emphasized very much. Your Honor, if you look at Article 1, Article 1, Article 1, sub-Article 1, says sovereignty of the people. All sovereign power belongs to the people of Kenya and shall be exercised only in accordance with his constitution. And 2, which is perhaps more important than what I've read to you, the people may exercise their sovereign power either directly or through their democratically elected representatives. It is now democratically elected representatives who are seized of this matter. And they cannot be controlled, or the issues that are before the court, before this select committee, cannot be washed or swept under the carpet by raising trivial objections at all. It's my humble submission that you overrule my learned friend. You don't have to waste time. And in doing so, you'll be guided by the able ruling that was delivered by our Speaker on 30th April 2024, which is before you. I don't wish to waste most of your time, or much of your time at all. I would prefer that we get on with the job so that we meet the timelines and we are able to proceed with the matter before you. Finally, I may point out that my learned friend, from what I can see, is trying really to buy time so that we do not finish this matter within the stipulated timelines we have been given. That's all.
Thank you.
Madam Chair, out of curiosity, if indeed the minister is innocent, why is he worried about the witnesses? This is a matter of national interest, as my lawyer has said. If indeed you are innocent, Kenyans want to know. Could be someone is trying to bring witch hunt to the minister. Let us be allowed to bring each and everybody who will set him free. The jury is in the public. When a minister, relax. Let Kenyans...
Honorable Amboka, we are just beginning the process, and please do not rush to the conclusion, and limit yourself to the time that we have given you. And may I also advise all the other parties to adhere to the time allocated during the hearing, and also the witnesses that that they cannot go outside time allocated to each party. Again, it is important to note that the witnesses' submission must fit within the time allocated. If we respect that, then we'll be able to conclude on time. Now, I would want to take this time to give the ruling as per the requests that both the parties made last evening. Honorable members, given the Constitution timeline within which the committee must conclude this process, the detailed rationale behind the decision on the preliminary issues and questions will be elucidated in the committee's final report. Having said this, on the preliminary issues that the affidavit is defective, we have overruled the preliminary objection, having looked at Article 152(7) of the Constitution and Standing Orders 47(4)(a), 64, and 66. Number 2, it is noteworthy that it is the exclusive authority of the Speaker of the National Assembly to determine the question of admissibility of a proposed special motion for dismissal of Cabinet Secretary, a matter that was already determined. We are now at the stage of investigation by the committee, the question of admissibility having been determined by the Speaker. Number 3, consequently, I direct that committee shall proceed to hear the matter and discharge its mandate as required under Article 152(7) of the Constitution. Number 4, as stated earlier, we shall give a detailed and reasoned ruling in our report on this matter. The question, can we admit new evidence? Honorable members, on whether the mover can call before the committee witness whose statement were not initially part of the motion as passed by the House, it is notable that Standing Order 64 primarily concerns procedural matters and does not prescribe the specific evidence to be presented before the committee. Number 2, what is important is that these investigations by this committee should and will not go outside the allegations in the special motion. Number 3, consequently, the committee shall allow any party to invite witnesses or produce new evidence, provided that the evidence strictly relates to the allegations contained in the motion. Number 4, the committee will not entertain any witness or evidence that is not relevant to or that purports to introduce new allegations outside the allegations as passed by the National Assembly. Number 5, we shall give a detailed and reasoned ruling in our report on this matter. Can the committee summon the Principal Secretary for the State Department for Agriculture and the Managing Director for KELS Chemical Limited as requested by the sponsor of the motion? The response, Article 125 of the Constitution, Section 18 of the Parliamentary Powers and Privileges Act, Standing Order 191, and our own rules of procedures gives power to this committee to summon any person to appear before it. Having said this, Honorable Wanami Wamboka should first provide the evidence for laying basis for the request so as to demonstrate the need for the exercise by the committee to summon the Principal Secretary for the State Department for Agriculture and the Managing Director for KELS Chemical Limited. The parties are accordingly guided. On referral of matters under consideration by the Select Committee, I urge all parties to restrain themselves from referring to the substance of the proceedings of the Select Committee before the committee has concluded and made up its report to the House. As per the adjustment of time, the committee has agreed that opening statement will take 40 minutes, cross-examination and under the sponsor and the cabinet secretary, we have given 60 minutes, and the rest of the witnesses 20 minutes. Closing statement 1 hour. The parties are, as I said, the parties are accordingly guided, and we will proceed.
Much obliged, Your Honor.
Thank you. Opening statements by Honorable Wamboka, and you have 40 minutes, sorry. As I said, we have allocated 40 minutes, and please be guided by the clock on the...
Asante sana, Madam Mwenyekiti. Of my 40 minutes, I'll give some remarks, then I'll allow my advocate to say something about the same. This is a case of gross violations of the Constitution, gross misconduct, and ministerial responsibility. National agenda of this administration of William Ruto on food security is noble. And from the onset, I must say, we support the president because agriculture is the backbone. If the country is food secure, then you have a healthy nation. It is too critical a matter for this country to be jeopardized. Madam Chair, various violations meted out against innocent Kenyans through distribution of fake fertilizer, as we will be demonstrating to this noble committee. Consumer rights have been violated, and someone must be held accountable. Ministry of Agriculture and Livestock has got a head who must take responsibility. In fact, in serious democracies, by now, the minister should have resigned. Honorable Committee. This is one of the flagship of Honorable William Ruto. And as I said, we support the president. And that is why I'll draw your attention to the voting in the House. Honorable Chair, it was bipartisan. It was bipartisan. That is how serious this matter is. I've looked at the responses from my good friend, and indeed is my friend, Mithika Linturi. There is a lawyer saying that says, I would wish that this should become this, so that I don't listen to what the Honorable Minister is trying to say. That, Honorable Chair, 149 members of Parliament, and indeed those who were in the House that day, will understand that there were more people. Cards were not working, and the Speaker ruled on this. 19 members, including the Honorable Nabina Bwera, my good uncle, the Honorable Mchomba, they did not vote. 19 members of Parliament who supported this motion and who were in the House did not vote. it should be understood that 24 members of parliament were out of the country, had petitioned the clerk of the National Assembly if they can vote virtually. 24. Those numbers are growing. It is incredibly unserious. Honestly, a whole National Assembly saying something is wrong. Something is wrong. And it will be very, whatever happens to this case, it will be very it will be not business as usual. Because that voting, it was a vote of no confidence to the minister. It has consequences. I would be keen to imagine how ambassadors will be dealing with it. Our good friends on high moral ground, the United States, the EU, of which we shall be appealing to them, that indeed the National Assembly has passed a vote of no confidence. In that alone, it speaks volumes. It speaks volumes. And I think the minister has guts even to be here today. This motion is not about me. This motion is not about the National Assembly. I had some good friends in Meru saying we are targeted. No, we have very many good Merus, including my good friend, who is at times my lawyer. He's a good Meru. He's a good Meru. It's not about Merus. Merus are good people, and I want it to be understood in this committee. It is not about Kenya Kwanza. Honorable Chair, it's not about Azimio. It is Honorable Franklin Mithika Linturi versus the Republic of Kenyan farmers and diaspora. I did indicate I come from a border town. Ugandans buy things from Kenya. Kenyans buy things from Uganda. My good sister would know this. Nahayo, the Iron Lady, would understand this. The Ugandans came and bought fertilizer from Kenya, subsidized. What should they do? What should they do? I have looked at the document submitted by my good friend Mithika Linturi, and it's nothing more than a love letter from a jilted lover. That these are grievous matters of national importance to be reduced to love matters. Ukiachwa hachika. Hachika. It is indeed unfair to keep dragging the good lady, my sister, Marianne, into these matters. She has a right kukukata, kukukubali. Allow her to proceed on with her life. Including the Honorable Chair, that it should be unfair that your private matters should keep coming up anytime serious matters are raised. The good lady should be left in peace because she has a life, she has a family, she has children, and she needs to move on. We shall speak. This is a select committee. We shall say that which we want to say and that which we think is important to this committee. I did indicate yesterday that very many people approached me to drop this motion. I refused. And in fact, I told one of them, I'm different from the Honorable Mithika Linturi. It should be understood, Honorable Chair, that the Honorable Mithika Linturi started a process such as this. This was going to be the second one in the new constitutional order. Had he been serious. He went ahead, he collected signatures, it was put on the order paper, his motion. What did he do? He went to Naivasha, was given money and love.
Yeah.
That indeed it is a demonstration.
Chair, I have a point of order.
Point of order by
Yes.
Honorable.
We've made it very clear that any statements made by a witness, the sponsor, or the respondent must be substantiated. Allegations have been made about going to Naivasha, money being exchanged. Unfortunately, we do not have any substantiation on that. Let's not use this opportunity to malign one another. I think we should observe decorum, and we must be welcome.
Honorable Chair, it is indeed in public. It is indeed in National Assembly records that a motion to impeach one Anne Waiguru appeared on the order paper. It is indeed in records of the courts. In the divorce case of the Honorable Franklin Mithika Linturi and Aldai Member of Parliament, Marianne Keitani, as to where the member...
Honorable Wamboka, I think you should limit yourself to the subject.
Well guided, Chair. That, Madam Chair, I'm a serious Kenyan. I had to do this, and I have done this. Those who don't know, I'm defined by Bayaya, Bala, Banyangali, and Watachoni clans. That definition, those sub-tribes cannot allow me to be bought, cannot allow me to be subverted. That is why we are here. It's because I'm serious, and I will die for the farmers of Kenya. The Honorable Minister has dragging me in, dragging strangers in the name of my alleged affairs, which cannot negate the fact that innocent Kenyans are suffering. I would want to understand, by you saying that so and so is Jack's wife, is the Honorable Member's wife, how does that relate to the suffering of Kenyans? How does that relate? And if indeed Honorable Chair of Justice Committee is fair, is only seeing one side when we speak, why should the minister bring no, I'm reacting. It is in his submissions.
I don't want this committee to be turned, this investigation to be turned into lack of investigation. Please limit yourself to your motion.
Yes, Honorable Chair, but it must be noted and be on record that in his submissions.
Yeah, point of order by Honorable Rachel, Dr.
Chair, I did not intend to interfere with statements that the Honorable Wamboka is making, but I would like to raise a matter on Standing Order 77 concerning the language that we use. And 77 says, all proceedings in the House shall be conducted in Kiswahili, English, or in Kenyan Sign Language. Twice, Honorable Chair, the Honorable Wamboka has mentioned words in a language that we did not understand, and I thought that he was going to translate so that we can understand. This may make us miss some of the information that he would like to tell us. So is it in order for him to use that language, which I'm not able to tell which language it is, because we are not able to understand that particular portion?
I'm sorry, Madam Chair. What I meant is I would wish that my ears become my sitting apparatus so that I cannot hear all this. That's what I meant. But well guided. Madam Chair, I've got one wife, which is public knowledge. This is not a forum to bequeath me with imaginary wives. And in any case, does it matter? I'm on this honorable chair because he brought it. If you look at his submissions, it's there.
Point of order, Chair. Point of order by Honorable Chair.
I believe it is very important that if you make a ruling, the honorable member understands that you are directing him on what to confine himself on. And Honorable Chair, if someone disregards that ruling, then you should be able to also call them out of order.
Well guided. Well guided. Well guided. But just to note, this is not a divorce case. Madam Chair, we are discussing the conduct of Honorable Mithika Linturi, that we want him removed from the office. Out of this world, I was just imagining, when he was being interrogated to be minister, he said he has in excess of 30 cases in court. We are all Kenyans, members of parliament. Why him? Why him? Why him? We are speaking. We have a saying in the Luya land. The hyena told the stone. You remember the case of J.M. Kariuki when they were investigating his death. Mwangale told his house. It's a house of records. The hyena told the stone that even if you keep quiet, you've heard me. Honorable Mithika Linturi, even if through the chair, even if you keep quiet, you've heard the cries of the Kenyan people. Thank you, Madam Chair. Now call my lawyer, the Honorable Dr. Haminwa, to give the balance of my minutes. Asanteni sana, Mungu ambariki.
Honorable members of Select Committee, I feel really privileged to appear before you. It is a great honor.
Point of order by Honorable Moses.
When you were speaking from there, we were having difficulties to hear you. But again, it's there. We are still experiencing the same. We are not getting well.
Okay, I'll speak loudly. I'm sorry. Your ears may be like mine. I'll try to speak loudly. Honorable select members, it's a great privilege to me to appear before you, particularly at my age. Last time I appeared in this matter of this kind was when we were handling Judicial Commission of Inquiry into Golden Bag. This was set up by the then President, Mwai Kibaki, and I had the honor and the privilege of being the lead counsel in that particular case. I thank the Honorable Member Wanani Wamboka for nominating me to appear for him in this matter. The matter you have before you is in some respects very substantially similar to the matter we had in Golden Park. Honorable members of the Select Committee, we have always had a problem in this country since we got independence. And the problem is of what I term, and some academicians term, portfolio corruption. Individuals who have been given portfolios and they are corrupt. The word corrupt here does not necessarily mean one taking money. but one not being responsible in his job or the job that he has been given by the president or by the state. This is the case we have in this before you today. What is important to look at is perception. Perception is important. Strictly speaking, in this case, one does not have to need evidence at all. It is a case that can be determined on perception. Honorable Linturi was given a high office of being Minister for Agriculture. If I may say so, this is perhaps the most powerful ministry in the government, which is supposed to take care of issues of poverty that we have in the country. He was responsible. He cannot turn around and say that I was not. He was responsible. And what I want to say to you, honorable members of the Select Committee, you must not try to determine this case on the technicalities. If you do so, you will be letting down Kenyans. I appear in the courts. Courts have got their own limitations. They have to go strictly by the law of evidence. Fortunately, before you, the law of evidence is not be all. You are quasi-judicial organ, and you are expected to look at this matter in a much broader manner than courts would do. Courts are technical, but you are not. You can decide to go a little bit. If not, look at the whole thing and see that is so and so guilty according to perception. And that's why Wanana Wamboki, the one who was instructing me, brought this matter before you as representatives of the people to look at the matter very, very broadly. There is a concept prevailing in academic circles or in books and so on called state capture. This country is under state capture because of corruption. And the corruption can only be minimized, can only be swept under the carpet if Parliament rises to the occasion. Courts may make a contribution, but they are controlled by technicalities, the law of evidence. This noble house is not controlled by technicalities at all. Let us go by perception. Let us look at the matter in this very broad manner and find out whether we can get a solution for the country. As politicians sometimes say, let us find out what Mama Mboga would say about this. And indeed, if you go and carry out a census to find out what Mama Mboga would say, Mama Mboga would say, Honorable Linturi should have resigned long time ago as a matter of principle. He should not continue to be a minister in charge of agriculture at all. I urge you very respectfully, let us move on with those few remarks. Let us move on as quickly as possible and go back to do some work. If I may borrow the words that my client has used. Mr. Linturi, you would have done us great honor by resigning. You would have set a big precedent, and you would have gone down in history as a big man. Thank you. I have my junior assistant, Lady Asha, who would like to say a few words. Please allow her to say something. Thank you.
allow her because you still have some time.
Yeah, thank you very much. Again, may I say you have been very kind to me. I thank you sincerely.
Thank you, members of this honorable committee, colleagues, and mine is to say that today is an important day in this country. This committee will set a precedence for this nation. This committee, honorable committee, will set a precedence in this country. The matter before us is not about the CS individually, but it's a collective issue that touches each and every Kenyan. The minister, as per even his documents, has mandate before the law, and one of the functions of the CS, just to highlight, is to appoint board members of public institutions. It is important throughout this hearing we will also highlight how that was not done despite it being his mandate. As we continue with the hearing, you will realize from the bundle of documents that there is a Fertilizer and Foodstuff Act that is Cap 345. The minister has duties directly to appoint a board. Honorable members, I request that we look at this matter holistically and we do not tie down this matter to a witch hunt as has been alleged. The minister was responsible to appoint the board. The board, as you can see, we will tabulate that as per the Act, is mainly to do the job of procuring, distribution, but specifically the issue of subsidized fertilizer. The minute the CS did not do that mandate that Kenyans, their constitution and acts of parliament gave to him, he actually saved Kenya. He actually put Kenyans in the situation we are in. It is important to note that as a result of that, there are various violations that arose from that act that he did not commit. Mine is to request this honorable committee to look at the matters before you in a holistic manner. Remember, there are Kenyans who are affected by this. This is a matter of national interest, and I thank the committee because there were rulings also from the previous Speaker Marende on issues on public interest matters in terms of technicalities. Again, I would request that we not only limit ourselves to looking at things that do not touch the subject matter of fake fertilizer, because that is the reason we are basically here. It's not that the mover of the motion woke up one morning and said, I want to impeach the Honorable Mithika Linturi. The basis of this is that as a public interest matter, there are Kenyans out there who have the fake fertilizer, and it is in public knowledge. So today before you, we want to stipulate what the CS has done in regards to the issue of fake fertilizer and stipulate the gross misconduct because we are guided by the Constitution. So I humbly request that this honorable committee does not look at it from one angle. The issue here, let's not have diversion in terms of the nitty-gritty, but more importantly, let us highlight the issue of fake fertilizer that makes a great impact to this nation because it affects the socio-economic rights, which is also an inherent right in the Constitution of Kenya. There are farmers out there who have not been able to have their produce, who have not been able to plant, and that had ripple effect not only to the farmer and the family, but to the economy and food security. So I would wish the committee to consider this thing holistically and look at the aspects that it touches. It's not about a witch hunt, about the CS. As Kenyans, we want to come to the bottom of this because food security is important to all of us. If there is food shortage, it affects all of us. Therefore, I request humbly and with humility that the committee gives us the time, just like they will give the Honorable Mithika Linturi time, to be able to table issues that touch the issue of fake fertilizer and the omission of the CS from his duties that resulted to what we are facing as a country. Thank you very much, honorable members.
Thank you.
My lady, I wholly adopt what my able-learned friend, Lady Asha, has said to you. And I reiterate very politely and very respectfully, let Honorable Linturi, Cabinet Secretary, go. He is not fit to continue to be in office.
Thank you, Senior Counsel. Honorable Wamboka.
Yeah, I still have some 11 minutes.
Okay.
Honorable Chair, one of the key, a minister must be trusted because he represents God. What a minister sees.
We apologize.
Chair, a minister holds that office in trust. A minister must be trusted. A minister has a duty to give the right information to Kenyans. As we will be demonstrating, this minister, my good friend, the Honorable Mithika Linturi, on this case of fertilizer, he gave the Kenyan public information over the same subject, 4 versions. Initially, there was no fertilizer. There is no fake fertilizer. Initially, there's only 3,000 bad fertilizer on the market. But the minister went ahead to even tell Kenyans about soil moisturizer. Honestly, we shouldn't have reached here. We should not even be discussing this matter because Kenyans need to discuss the minister. Kenyans need the truth and nothing but the truth. As we will be demonstrating, this is not the first time we have scandals in that ministry. As part of the reasons why, if you go through a submission, the minister should be impeached. This is not the first scandal in the Ministry of Agriculture and Livestock Development. We had the sugar scandal. Kenyans kept quiet. Someone had to speak, Madam Chair, about this. We have a lot of trust in this committee. Because as members of parliament, we are people's representatives. And the good thing, when I look around, composition of this committee, most of them are from agricultural zones. Most of them. Kenyans are watching us. I have absolute trust that we are going to get to the bottom of this. And if 149 was not enough, while the minister was waiting for 250, we shall give it. We shall give him. We shall give you, Mr. Minister. We shall give you. Because the mood in the country, the mood in the National Assembly, Madam Chair, is so sweet. It's so sweet that Kenyans are tired of such things. We have now higher cases of diseases. Some of them as a result of this. We are waiting for reports from medics. To what extent has the fertilizer affected humanity? Where it come from? Madam Chair, there's no maize anymore. We don't have it. I don't know what this government will do. I don't know. Even if Honorable Linturi were to remain, I don't know what he will do. I don't know what he will tell those people from Western, from the Rift Valley, from the highlands of Kenya, from central Kenya. I do not know, because we don't have food. Kenya is glaring at a catastrophe. Courtesy of an individual. Be the Yonah, be the biblical Yonah. When the ship was sinking, Madam Chair, when the ship was sinking, because of one person, Yonah opted to drop himself in the waters. It is a moral question, Honorable Minister, for the sake of Kenyan people. Whether, assuming this motion does not go through, assuming, how will you serve? Where will you go? Where will you discharge your mandate? Kenyans are bitter. Be the biblical Yonah, and we shall respect you. That's all we are asking, Madam Chair. Not that anyone hates the person of Mithika Linturi. No. As I said, he's my friend. His best friend and a lawyer, Gitonga. We share a social group called the Chairman's Lodge. He is my wakili, the man seated on his left. He is a family friend. I've been to his place when I was campaigning. These are the people who came to my home. So there is nothing personal. Nothing absolutely, Honorable Chair. Nothing personal. Nothing. In fact, we are saving him. We are saving him. Because how will you serve? How will you go to Bumula? How will you go to Ahero? How will you go to Mbere, Embu? How will you go to Kiambu? How will you go to the food basket of this country, Trans Nzoia? How? And as a minister, you must go. How? Those Kenyans will not allow you, because they are angry and not happy. They are angry. We support the president, William Ruto. We support him on this, the policy of food security. We support him. We support him. And at times politically, you know, politics at times is very tricky, Madam Chair. When someone has committed a crime, you go back to your people and say, I'm targeted. I'm targeted. And people start sending delegations. Oh, go. Enda sema mambo mzuri. Enda sema ukiguza Linturi umeguza Wameru. Hapana. Sio Wameru bwana. Wameru ni watu wazuri. Tuwaheshimu sana ndugu zetu Wameru. Hata Mithika ni mtu mzuri, lakini mambo haya yamefanyika kwa wizara yake. So we understand, and that is why we are helping the president. We are helping the president. It is the parliament, it's the National Assembly that has sat Honorable Linturi, as it were. It is not the president. I know the president's hands may be tied. Tafadhali ndugu zangu, tuwakilishe Wakenya. Wakenya wameumia na wanaendelea kuumia. Na wanaendelea kuumia. Na wanaendelea kuumia. That a minister can give 4 different versions of the same story, it is a disaster. A disaster. That a minister can go, as we will be proving to this house, to talk to someone else that, please, I need you to save my job, as it was given to the Agriculture Committee. Please take responsibility on my behalf. I will protect you. That is what we are discussing here. So what is it that you want to tell Kenyans? Someone else should come and shoulder your responsibility so that you protect him? But what about those farmers?
Honorable Amboka, you have 2 minutes.
Yes. In fact,
50 seconds.
I'm done. I'm just waiting for the time. What will you tell those farmers? What will you tell those farmers? Senior, you want to conclude?
Yes, I want to conclude.
Yeah, let you say something.
Again, my lady clerk, may I borrow some words from you? You mentioned something that may I say, touched me. That let us not trivialize national issues by bringing in love. I was reading a response that has been filed before the honorable members of the Select Committee. And the main defense appears to be that what is before Parliament of Kenya, National Parliament of Kenya, dealing with the grave national issues, is because of my ex-wife. My ex-wife is the one who is bringing trouble. Unbelievable. Unbelievable that you should trivialize a matter of national, international issue and say it's my ex-wife who's doing this. Let us not invoke mundane, primitive concepts of love, of tribalism, of religion. Those no longer make sense in Kenyan context at all. We are all nationals of Kenya. We are all concerned about Kenya. We want Kenya to move on and become like Singapore, become like Korea, the way those people came and lived in this country, studying the way that we are doing things that they were very much impressed. They have developed more than ourselves. And we have gone backwards because of corruption, portfolio corruption in the country. It is only Parliament that can save us. If it is marriage, we intermarry. I had a Kikuyu wife. Unfortunately, she died. I loved her. When she died, I cried. She was a good woman, Joyce. She became a judge. My son, the firstborn, unfortunately, is dead. He was married to a Meru lady. I never objected. She was a good daughter-in-law. So these things of invoking tribalism, invoking love and so on, must cease. And you as Parliament, you must rise to the occasion and tell people like Linturi, go, we have had enough of you. Thank you.
Thank you, Senior Counsel. Honorable Wamboka, please provide us with the list of your witnesses so that the members can know the individuals who will be presenting you.
Last one, my last.
Please provide the list to our secretariat and we will proceed.
We have supplied a bundle, this bundle that is supplied to the whole committee, part of the committee. The list is at page 193 of the bundle. It consists of a list of documents and witnesses.
Thank you.
Yes.